So emergency protection orders, they don't happen by default. They need to be applied to but a judge has the authority to order an emergency protection order when there's been domestic violence and an order is required for the protection of the person or the property. One good thing about the Act, to give credit where credit is due, is a very expansive definition of violence. So it talks about violence, and so the definition, traditional definition of violence, the application of force without consent, it specifically talks about sexual violence. It talks about damage to property, which is good, so it can be, before it escalates to the point of actual physical violence, and people are damaging property and that sort of thing. And it also talks about threats as actual violence. So it says if someone makes a threat, that is a serious threat, that would be enough. So I think that's good, because that means that if you're working with someone who has said, my partner has told me that they will do this to me, and I'm scared that that's really going to happen. On that basis, you could go and get an emergency protection order. So that's good that it's so broad. But it does need to, you need to have both of that. So just if some violence happened, for example, and then you couldn't show that you needed this order for protection, I don't know why, maybe someone went off to jail, so the judge could say, well, you don't need this order for protection, they're in jail. So you just got to make sure you've got both parts of that. And so what are you allowed to ask for? The judge can order exclusive occupation. We may have talked about that already today. That just means that you get to be the one who lives there and not the other partner. They can order that the other person has to leave. So there's a situation where there's an abused person, but the abuser is staying put. You can get an order saying that that person has to be removed. You can get an order that the person has to stay away, and that sort of thing. And it can be up to 90 days, and it can be renewed. So that sounds really good. That's a positive development, because before there was nothing. There was nothing you could do. I think, though, I would say that the problem, and we'll talk some more about some of these problems, but those of you who work with non-Aboriginal people, you may have, I don't know whether you ever tried to go and actually get an emergency protection order. They're not the easiest things to get, because you have to go to court, and you have to sort of get paperwork, and there's a bunch of hoops you have to jump through. So it looks good on paper, and it's an important protection, but it's not like someone can just walk into your office and say, hey, I got beat up yesterday, and I can't go home, and I need to go home. Can you just go and get me one of those emergency protection orders? It's not that easy. So occupation, the right to be in the house, or the trailer, or the apartment unit, or whatever it is we're talking about. This says that if you're in that conjugal relationship, if you have a spouse, or you're in that common law relationship, you have, while that relationship is ongoing, as much right to be there as the other person. Which sounds really basic, but that wasn't written down before, so it's good that it's written down now. The one thing that's sort of automatic in this act is it says that if one partner dies, the other partner has the right to be in that house without having to go get an order, without having to have it in a will, without anything like that for 180 days. Again, that wasn't something you had a right before. So you could have had a long-time couple who lived together for 40 years on a reserve, but if the person who died was the person who was the First Nation member who was registered by law, another family member or the First Nation itself or someone else would come and knock on your door the next day and say, sorry about your loss, please leave. And you have no right to do anything other than to go to court and try to make arguments, but because that judge didn't have any authority or property on anything, that could be kind of out of luck. So that automatic, you get to stay for 180 days, gives you the time, gives that partner, surviving partner, enough time to then make other decisions about what the legal steps they might want to take. So that's the one thing that kind of happens automatically. And after separation, either, or I suppose both, partners can apply to a court to figure out how you're going to divide that property. Because you have a 1/2 interest in that property. Again, it sounds pretty basic. It's family law, you're in a relationship, looks like marriage, you have a 1/2 interest. It was never written down before. But what's important to see about that is you have to apply to a judge. So on that moment, you say, okay, that's it, we're ending a relationship, we're separating, Now, how am I going to get that 1/2 interest? What do I have to do? I mean, again, like so many family law situations, if we can work it out together, and that's great, you know. But if we can't, then one of us is going to have to go to a judge and explain why I should have that 1/2 interest, and how that's going to happen. And I'm sorry, I skipped. I'm talking about separation and occupation here. 1/2 interest is about getting the value of the property, and we're talking about occupation, which is about the right to live here. Sorry, I drew that line between those two things, and I totally muddied it. The line, we're talking about occupation in terms of making that application. You want to say, I want to keep living in the house. We've separated, and I want to keep living in the house. You want to decide who has the value of it, but I just want to keep living here. You can make an application to a judge to do that. And the judge is supposed to consider the things that I've listed here to decide if you should get to be the one who lives in the house. And it's complicated because things like best interest of the children, agreements, or have you had any agreements in the past? Did you enter into an agreement either now or in the past about what would happen if you guys split up? But the collective interests of First Nation members and representations of the First Nation Council, length of the time on the reserve, your financial situation, your medical situation of the spouse, and the availability of other on-reserve accommodation. Those are very hard things to balance. If you think about someone coming and saying, I want to stay in the house. I've lived here for 5 years. I have 3 small children. They go to the school. I should have the right to stay here. And then you think about maybe the representations of that First Nation who might say, we have so little property. We have chronic problem under housing in this community. We have people living 10 to a house. That person is not from our community. They have resources elsewhere. We have tons of other kids who need housing. You know, judge, this is our land, and we have the right to make decisions about our land. Let us decide. Let us put someone else in the house. These are very difficult issues and very hard rights to balance. So, like in all family law disputes, you know, what's right for the kids, what's been the pattern in the relationship, what's the history, those things are all going to be important, but then you can be hard enough, and then you add this layer on top of it of, what about the fact that this is supposed to be a collectively held piece of property? So those are sort of how it works to answer the question about occupation, which is who gets to live there.